So this video is going to cover the rules in regard to consideration in contract law. So broadly speaking, consideration is the thing that each party has to put into the bargain in order for a contract to come into existence. So there are a variety of rules on consideration, and the first one is that consideration doesn't have to be adequate, so it doesn't have to be the market price. This is first of all illustrated in the case of Thomas and Thomas. In this case, a widow was allowed to rent a property for only £1 a year. The family of the person who made this agreement said that this was well below market value and tried to argue that it wasn't good consideration. The court held that £1 a year was valuable consideration and therefore it was enough to complete the contract. So even though the £1 a year was well below the market value, it still had some worth and therefore it was valuable consideration. This situation is also illustrated in the case of Chappell & Co. and Nestlé & Co. In this particular case, Nestlé had a special offer that if you sent 7.5p and chocolate bar wrappers, you could exchange them for a record. It was then argued that the chocolate bar wrappers were not good consideration because they would be thrown away once they were received back by the company. The court held that the wrappers were part of the sale price, and yes, they were valuable even though they were just going to be thrown away. So the second rule is that consideration must not be past. It must be linked to the promise and cannot become before or after the promise is made. This can be seen in the case of Roskala and Thomas. In this case, the claimant bought a horse from the defendant, and after the sale was made, the defendant promised that the horse would be sound and free from vice. In actual fact, the horse proved to be very vicious and very hard to control, and the plaintiff sued for breach of contract. The court said that he had no case. The only consideration he had given was that the sale price of the horse was passed by the time the promise was made, and the contract was merely that the defendant would deliver the horse on request. Because the promise had been made and the agreement had taken place, so the contract had been formed, the fact that the defendant had promised that it was sound and free from vice was not included. In the case of Rima Cardle, the consideration was first and then the agreement. In this case, the occupants of a house carried out various repairs and improvements. After the work was completed, the beneficial owners of the house promised to pay for this work. When the owners failed to pay, the occupants sued them, but without success. The consideration that promise was passed and there was no contract. Finally, consideration must move from the promisee. The person who wishes to enforce the contract must show that they had put in consideration, and it's not enough to show someone else provided it. The consideration does not have to move to the promisor, thus the benefit can move to a third party. So both parties must usually put something into the bargain is the usual way that things work. However, this basic rule has been altered by the Contracts Rights of Third Parties Act 1999, so the outcome of the following case would actually be different. But the rule that consideration must move from both parties can be seen in Tweddle and Atkinson. In this case, the fathers of William Tweddle and his wife entered into an agreement to take effect that they would both make a payment of £200 to the husband on their marriage. The husband's father made his payment, but the father-in-law died before making the payment. The husband sued, but his claim was not allowed on the principle that although he would have benefit, he was not privy to the contract. Use the notes that you've made listening to this video to complete an answer to the following question, which is worth 7 marks. Explain the meaning of the terms consideration and past consideration.